It has been proved in the nomination paper filed by Meenakshi in the Form 26, she did not disclose, thereby filing an incomplete. She doesn't require to disclose. There is no charges framed. Why should she disclose? Look at Mullis, the failure of governance. The election commission keeps quiet. No order is passed. They can easily have reversed the RO. I mention here, and the matter comes today, and overnight they declare the result. This is not Mullis fair. What is she only seeking a participation? She can lose the election.
Towards any judgment in which we have interfered.
This is one of the law. Your lordship has, forget this case for 30 seconds. The lordship has an RO writing 2 plus 2 is equal to 6. Will your lordship say, Mr. Singhvi, you wait till she will not win the election? She will only fight an election. You are excluding her at the threshold. Let her fight and lose. And today, the only thing my lord has to do is to remove to set aside the RO order. The consequence follows. She's only standing for election. And look at the conduct. EC silence. My lords is listing it today and they declared the result last night. Not shocked, then I'm out of court. But just follow the sequence. First turn to section 33A at page, to make it simpler, at page 82 of the file.
Page 82.
Yes, of course the section will be there in your lordship's book also, but just take it at 82.
Yes.
And I assure my lords, I'll keep within the discipline of what my lord said yesterday.
Yes.
Now this is the section. If you forget the law, the jurisprudence, the case law, this section is enough. 33 capital A is your lordship's ROPA, which governs the election commission.
Mm-hmm.
A candidate right to information. A candidate shall, apart from any information which he is required to furnish under this act or the rules made thereunder, in his nomination paper delivered under 33(1), also furnish the information as to whether. Now mark I. The first one is enough. He is accused of any offence punishable with imprisonment for 2 years. No problem. Doesn't apply in this case. Yes, it is 2 years and more. In a pending case in which a charge has been framed by the court of competent jurisdiction. This is your lordship section. If your lordship recollects, this was made after my lord's judgment in ADR, the Association of Democratic Reforms, that judgment. It's only a disclosure requirement. Now note, bullets, that this section is followed by another section 223 of the BNSS, the new one, which is 84, page 84. Your lordships in the new act adds a proviso consciously that before you take cognizance, you shall hear the potential accused. It's actually only a potential accused because without cognizance, there is nothing in the eye of law. Now, please note, I am not concerned with cognizance. I am concerned with charges being framed. My lord has read the section. But cognizance in a private complaint is the first step. My lord knows, I file a complaint. He takes cognizance. It's a private complaint. Cognizance he takes. Then there is investigation. Then there is a charge sheet.
No, but summons has been issued to you.
Yes, but no cognizance has been taken. Dates have been given. It's only a notice to me to attend under the proviso. Come to 84.
Once a summons is issued,
yes,
the court will issue the summons only after prima facie satisfying itself.
So there are two.
That there is some
two arguments.
Issuance of summons.
So there are two arguments. One is summons is not enough. Even cognizance is not enough. The section says charges have been framed. Please see page 82. The section requires charges to be framed. So this is not enough to have cognizance. I am showing something here for sure. The court under page 84, turn to 84 minutes, under the newly enacted proviso, this is a proviso enacted new, is required to actually pass an order consciously taking cognizance. I'll show the order sheets in a minute.
Yes.
Provided that no cognizance, no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, on this matter, he has to hear me and therefore say, okay, I've heard you and I now take cognizance. Now, turn to the order sheets. First order sheet is 26.8. I'm now going to read it. Then, Malas, let me just see the general context. He is not taking any application, only giving dates. Then, 25th September, I am accused 4, Malas. In the third line. Come, appears, memo filed, reply, rejoinder. Then next page, 72. I will not read. Just glance at the whole of 72. Page 72 again.
Yes.
Sorry, my lord.
No, the name of the presiding officer you are just.
Suvarnalata.
Yes, Lord, please proceed.
Yeah. 72.
Yes.
The whole page is order sheets. No application of mine, no reason, nothing. Now turn to 73. Whole thing is order sheet. In the middle of 73, in the first para, he says, to the court time has lapsed, the matter taken up after 5:15 p.m. Then turn to 74, it ends. Give me just 1 minute, Momulas. 75 is another set of order sheets. Who is present, who is not present, counter filed, not filed. 76 is the same. That's it. 77 it ends. Now, Malas, please note that the order passed by the RO is bizarre. So, Malas, if there is no cognizance, there is no case in the eye of law to disclose. Even if there is cognizance, I have to disclose after charges are framed. Now, one very strange thing, I'm sure this is rank injustice. Bear with me for a minute. Lordship will kindly pay attention here just for a minute. The complaint is not against me at all. Just turn to the complaint. It's very interesting. Then I'll come to what is the law, that your Lordships can hear this. Page 39. This is bizarre, Malas. If Malas the RO acts arbitrarily and says, I disqualify this man, so everybody of one political color alone will stand, then it's interferable. Turn to Malas, page 39. This is the complaint. Now, mark this, Malas. This is a complaint of 2025. And just note two paras. In this way, the level playing field can be made non-level, then Malas, there cannot be any elections in this country. The complainant submits that she joined politics and became a corporator from 2 to 7 of TDP party, 2-time standing committee. Mallory got it?
Yes.
This is the complainant. Now come to 4. The complainant submits that she had given complaint against Kumbam Shivam Reddy. This is important. For physically molesting and giving life threats to her, which was culminated into an FIR against Kumbam Reddy in 22. Just mark that date. 3 years earlier.
Yes.
Then let us come to para 5, next page. He is from the Reddy community. I am a backward class lady. Blah. Now come to Malas. The only place I am mentioned, my name is Meenakshi Natrajan. I became in charge of Telangana.
Date of offence is 11/5/25, not 22.
No,
Complaint.
22. No. Please turn to Malas, para 4. I'll tell Lordships in a minute. I know what my Lord is seeing. Just bear with me. Just come to para 4. Just park that point. Just come to para 4. Now, this complainant submits that she had given complaint for physically assaulting and molesting. On 7/5/22, she gave the complaint. Right, Malas? Now, para 5 is she is from so-and-so community. Now, I am in para 9. I am in charge of Telangana, appointed 3 years later. I am nothing to do with Telangana. I was appointed in charge of Telangana. The complaint is that you, Miss In Charge, never took action. I am actually not even a witness. Bear with me. Let's just see para 9. The complainant submits that she had given several representations against Reddy to take disciplinary action. There was no response. I approached AICC's this complainant. Mr. Spencer Lal demanded on 10th May to take disciplinary action. Then AICC in charge, Telangana, me. So this is the only place I mentioned. The second place I mentioned in para 25. Just turn. This is the totality. Para 25 is page 52. The charge is that he molested me 3 years ago. I filed a complaint. You were appointed in charge 3 years later. You do not take action.
Para 25.
Yes. This way you can disqualify a person from standing in an election. The Congress party has awarded the post of PCC member to Shivasumar Reddy. Never active in physical, but just because Shivasumar Reddy was PCC president, as I had filed a complaint, in 22, Reddy was aspirant of the MLA because MLA ticket was given to Parneka Reddy, Congress, a relative of his. All good terms with Reddy and thrown me out of party as complainant don't have influence and moreover belongs to the backward community. Parneka Reddy won the elections by saying complainant has filed false case. Now ignore all this, come to the next page. 53. That's the totality of the complaint. 53, 5th line, 7th line. Yes. Look at the injustice, brother. I am trying to shock my conscience. Otherwise, I am out of court genuinely. I don't deserve to be in court. Now, AICC, middle of page 53. Now, AICC in charge of Telangana, who is appointed in 2025, Malas. The incident is 2022. Meenakshi Natrajan has appointed Parneka Reddy as General Secretary on 25 July. Shivkumar Reddy distributed, etc. Now, Malas, please come to the RO's order. This is the way the RO is not supposed to be even argued by me. He has to see the law first. Your Lordship, suppose he is the RO. He has to sit with the ROP and it's a Bible for him. 33 I have read. Charges have to be framed by the court. Now come to his order. It's an amazing order. So page 22, annexure P1, first annexure. Now let's ignore the objections. At 22, there are the objections raised. Basically, this case pendency has not been disclosed. When no cognizance is taken, no charges have been framed. Now let's come to 23. Look at the way he decides it. Upon examination of the record, I am concerned only with a small part, but I'll read all for completeness, just half a paragraph. Case number so-and-so has been filed before the Honorable Court as a private complaint. My Lord's got page 23. I'm very sorry. Just misunderstood.
Yes.
23. Case number so-and-so has been filed as a private complaint. Cognizance of this complaint has been taken by the Honorable Court. Where? After the proviso in BNSS, a cognizance is because I say notice to Mr. Khurshid, give a date. Again, second time, notice to Mr. Tanka, give a date. Where is the cognizance? This fact is evident from the copy of summons. So summons is automatically cognizance, automatically, without a word. Then after proviso is amended, then these summons have been issued in the name of Srimati so and so. In the records, Srimati so and so filed a written statement.
But your difficulty is not this.
No, that I'm coming to straight away. This is
Difficulty
now,
is 320.
my Lord Justice Mishra rightly put to me, there is a constitution bench which covers me that your lordships can and should interfere today. From the records, the following facts are established. It has been proved in the nomination paper filed by Meenakshi in the form 26, she did not disclose, thereby filing an incomplete. She doesn't require to disclose. There is no charges framed. Why should she disclose? It has been. Why will she not disclose? She's an election candidate. If she had any idea of the, it's a criminal case pending. Why will she not disclose? It has been proved that it has taken cognizance. Second error, repeated again, patent error. It has been proved that Meenakshi has filed a written statement before us. Accordingly, facts proved stand against. This order is passed on 9th June. Just give me a minute, fellas. On 9th June, go and argue before the Election Commission. I personally made the arguments for 1 hour. Not a word is spoken. The Election Commission, the custodian of a constitutional duty, decides to keep silent till today as I speak. It is reprehensible, Balas. We turn to the Election Commission almost at the level of a Supreme Court. Balas. Your Lordship has a very high status. Your Lordship has seen the terms of conditions as a Supreme Court judge. Now, it doesn't say no order is passed. Now, this, Balas, is 9th. On 10th, I mentioned it yesterday to your Lordships. I'm sorry, I mentioned it 11th. 10th, we went to Election Commission. 9th is the order.
No, 10th it is upheld by the commission.
What? No. No. 10th, we go to, I'm sorry, I made a mistake on the dates. 9th is order is passed, comes to us in the evening. 10th, we argued. No decision by election. 11th, I mentioned it, and I told my lords that the genuine apprehension is that they will declare. Now, what happens is declaration is of one party only. Malas, when you exclude me, there is no party, there is no election. So, on the date of withdrawal, which is yesterday, it is declared because there's nobody else. Now come to the law. My lord rightly put to me, the law is quite different from what is commonly assumed to be. Forget it now, please. Now let's come to MS Gill. Give MS Gill. And exactly what I have argued before your lordship is argued before the RO. Now let's kindly. And we are talking of, your lordship, remember, Indira Nehru, Gandhi versus Raj Narayan. Your lordship said non-level playing field is a violation of basic structure. In the election field, it's basic structure. It goes that high. Give a copy. Now this is commonly forgotten. Gill was a constitution bench. Come to a very interesting para and the exact lines covering our case. Para is 34. This is the question Justice Mishra asked me yesterday and I'm duty bound to answer that. I'm duty bound.
Para?
34. Yeah. Now, the first 10 lines may be ignored. In fact, the first 15 lines may be ignored. This is very important. It's usually forgotten. My lord rightly mentioned Ashok Kumar. I will read that. But this is more important as well as a constitution bench. See the last line after 11, 12 lines. But what is banned is not anything whatsoever done or directed by the commissioner, but everything he does or directs in furtherance of the election, not contrary. So if he furthers the election, your lordship will not interfere. If he stops it, your lordship will interfere. For example, after the president notifies the nation on the holding of elections under section 15 and the commissioner publishes the calendar under 30, if the latter, the commissioner, orders the returning officer to accept only one nomination or only those which come from one party, exactly our case, as distinguished from other parties or independents, is that order immune from immediate attack? We think not, because the commissioner is preventing an election. There is no election. He declares the result yesterday. And I mentioned it in the morning. Well, good governance requires that without your lordship saying so, they should have said, we will not declare the result for 2 days. It's not a cat and mouse game. I go to the highest court of the land, and before I go home, they declare the result, and I only come tomorrow. Because the commissioner is preventing an election, not promoting it, and the court's review of that order will facilitate the flow, not stop the stream. Election, wide or narrow be its connotation, means choice from a possible plurality. Beautifully put, Boris. Monolithic politics not being our genius or reality, and if that concept is crippled by the Commissioners Act, he holds no election at all. This is what he did yesterday evening, knowing that I had mentioned it to your lordship in the morning. Now let's come to para 92. Two limitations, B, the summary of this judgment. Look at the failure of governance. The election commission keeps quiet, no order is passed. They can easily have reversed the RO. I mention here, and the matter comes today and overnight they declare the result. This is not fair. What is she only seeking? A participation. She can lose the election.
Towards any judgment in which we have interfered.
This is the law.
Interfered by accepting the nomination after once it is rejected by the RO.
No, your lordship will only set aside. No, I will. There are orders.
One nomination is rejected as on date.
Yes, the orders of the election.
So, commission judgment of Supreme Court.
No, election commission has reversed its own RO. That's what we argued before them.
Forget about election commission. You are in court.
Yes.
So was any judgment of this court where after the nomination of a candidate in a parliamentary or legislative election, we have set aside that order of RO and accepted the
May
nomination
I answer, Wallace?
for contesting the
May I
election.
answer, Wallace? That will depend if a case came on the facts here on the first day after the election. This is the law I am reading of a constitution bench. If the facts come, your lordship will apply the law. Today, my lord is to apply the law. Now, the facts may not have come to your lordships. That doesn't mean the law will change. My lord has asked me a question. Let me give a very frank and candid answer. If a fact comes to your lordship with such speed as I have brought it, 9th is the rejection, 10th I'm in the EC, 11th I mentioned to your lordship, and 12th I'm standing here, then your lordship will apply the law. The law is to be applied. It is not to be believed that a fact situation will not make the law. Now we'll just see 92. Two limitations at least are laid on its plenary character of the exercise. That is, whereas the election commission's plenary power is made limited. Firstly, when parliament or any state legislature has made valid law relating to or in connection with elections, the commission shall act in conformity with, not in violation of such provisions. Who made the law, Malas? Your lordship made it in the ADR. It was enacted in 33. It governs this election commission. Not in violation of such provisions, but where such law is silent, 324 is a reservoir of power to act for the avowed purpose, not divorced from pushing forward a free and fair election with expedition. 324, your lordship will implement in spirit. Secondly, the commission shall be responsible to the rule of law, act bona fide, and be amenable to the norms of natural justice insofar as conferable to the canons, etc. Fairness does import an obligation to see that no wrongdoer candidate benefits by his own wrong. To put the matter beyond doubt, natural justice enlivens. Now, Malas, it's no answer to say, well, suppose, just take the test. I'm answering the test Justice Mishra has put to me. Tomorrow, the RO writes 2 plus 2 is equal to 6. It's possible. According to me, this is a case of 2 plus 2 is equal to 7. He has to read 33A only. Your lordship has text there.
He has gone ahead according to you.
I beg pardon?
In calculation, he has gone ahead.
No, but I am ahead.
Instead of 6, he has gone to 7.
I think its error is 7. He has written maybe only 6. Both are equally bad.
Yes.
Now, my answer is very interesting. Manas. Your lordship has, forget this case for 30 seconds. Your lordship has an RO writing 2 plus 2 is equal to 6. Will your lordship say, Mr. Singhvi, you wait till, well, your lordship knows that old joke, Manas. Your lordship in the election law wrote down 6 months, when your lordship must have been a high court judge. Your lordship may have sat on the, used to have in the old days Friday, first the election tribunal.
Yes.
Then your lordship single judge as a high court used to sit on Fridays.
Yes.
6 months is written in the act. Whereas if you have very extraordinary devil's luck, you get an election petition decided in 3 to 4 years.
That is what
Normally, Wallace, we come
That
after
is what-
6 years,
that
after the
is what-
term is over.
one learned or honorable judge of Chennai, the High Court has said recently.
And that is,
circulated.
well, this law was enacted in 1952.
Yes.
You shall make an endeavor to decide in 6 months. So, well, these are all realities. Injustice, Wallace, will not stop your lordships. Now come to a second case. This is the best case. It's a constitution bench. It directly deals a reservoir. Wallace, what does it matter? She will not win the election. She will only fight an election. You are, Wallace, excluding her at the threshold. Let her fight and lose. And today, the only thing my lord has to do is to remove to set aside the RO order. The consequence follows. She's only standing for election. And well, look at the conduct. EC silence. My lords is listing it today and they declared the result last night. It's a, well, lordship has said in many cases, once your lordship is in seisin of the matter, you are the Supreme Court. A seisin of the matter can't be taken away by saying, yes, we are watching. Tomorrow morning you're going to sit. In the evening, I'm going to make it infructuous. That's not a cat and mouse game, Malas. Now kindly come to Ashok Kumar, which is the case my lord rightly mentioned yesterday. That's only 3 judges.
No, just
It's a constitution.
still, I
I'm
don't.
sorry to intervene, my lords. May just see paragraph 3 of the same judgment on the same
That's
page.
the normal principle.
Yes, that's all I don't.
Yes, yes, technicalities will not stop injustice being dealt with. This, why was this para put in 34 and 92 in MS Gill? It's not a vanilla formula that the moment an election is in process, my lord will say, come afterwards an election petition. That's the vanilla, routine, blanket thing Mr. Mehta is saying, wrongly. The exceptions are more important in this case. Suppose the RO writes 2 plus 2 is equal to 7, your lordship will not
The Constitution
go to the election petition. Now kindly come to
Lord,
Ashok
I am
Kumar.
reading Mohinder
Mr.
Singh
Mehta,
Gill
allow me to finish,
Constitution bench, which my learned friend read.
Mr.
Para
Mehta, I'm not
126
finished.
of this.
Please, hold your peace. Come to this other case. 2.
So you deliberately missed the most relevant
You
part
get your
of the
time to
judgment.
read all
Sorry.
these I missed. Please. Come to para 32.
Yes.
Page 232 of this SCC online.
मीनाक्षी नटराजन मामले में माननीय सुप्रीम कोर्ट के इस बड़े फैसले के बाद अब मध्य प्रदेश की राज्यसभा सियासत की तस्वीर पूरी तरह साफ हो चुकी है। देश की माननीय अदालत ने साफ कर दिया कि चुनावी प्रक्रियाओं के बीच अदालत का सीधा हस्तक्षेप मुमकिन नहीं है और कानूनी नियमों के तहत चुनावी याचिका यानी इलेक्शन पिटीशन ही एकमात्र संवैधानिक रास्ता है। माननीय अदालत के इस फैसले और कानूनी बारीकियों पर आपकी क्या राय है? अपनी कीमती राय कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।